Hello, and welcome to Workshops on the Web presented by the Ventura County Superior Court. My name is Joanne Johnson, and I am the Family Law Facilitator for the Superior Court. This video workshop consists of a video screen which operates like any other video player with play, stop, and pause buttons. The text version of the presentation is in the right half of the screen. You will need to use the arrows or wheel on the mouse to advance through the text. The laws in California regarding child custody and visitation in the family courts are extensive and can be found in the Family Code, Rules of Court, local court rules, and various cases which interpret these codes and rules. This video is designed to give you a basic understanding of the laws and procedures regarding child custody and visitation in the family courts. If you would like specific legal advice regarding your particular situation, you should consult with a private attorney. The court must have jurisdiction, the power, to make custody orders. California must be the home state of the minor children when the court case is first filed. The home state is where the minor children have resided for the past 6 months. Once a court in California has made custody orders, it has continuing jurisdiction to modify the orders, even if the children have left the state. California may decide to release jurisdiction to the state where the children have moved if requested to do so and the order is registered in the other state. The laws pertaining to jurisdiction are complicated and are set forth in the Uniform Child Custody Jurisdiction and Enforcement Act, the UCCJEA, in the Family Code at Section 3400 through 3465. If the court does not have jurisdiction over the minor children, any orders made can be challenged at any time. Venue pertains to the appropriate county for the case to be heard. In parentage actions, the case should be filed where the child resides. In divorce cases, the case can be filed where either party resides. If a party believes the case is filed in the wrong county, that party can object to venue or ask for the case to be transferred. Unlike jurisdiction, improper venue does not mean the orders are invalid. If a party does not challenge the venue, then the objection to venue is waived. Usually, the parties and children all reside in the same state and county. If your children do not reside in California or live in another county, you should speak with an attorney or the family law facilitator before filing any court documents. There are two types of custody, legal custody and physical custody. Legal custody is the right and responsibility to make decisions regarding the health, education, safety, and welfare of the minor child. This is the decision-making part of being a parent. Physical custody relates to where the minor child resides or how much time the child spends in the care of each parent. Each type of custody may be sole, only to one parent, or joint, to both parents. Sole legal custody means that one parent shall have the right and responsibility to make the decisions relating to the health, education, and welfare of a child. This does not mean that the other parent loses his or her custodial rights. However, this parent cannot make the decisions for the child, and the parent with legal custody does not have to get permission from the other parent to make decisions, unless somehow restricted by an agreement or court order. Sole legal custody is usually ordered only in the situation where a parent is unavailable, incapable of making joint decisions, has committed domestic violence, or abuses drugs or alcohol. Joint legal custody means that both parents shall share the right and responsibility to make the decisions relating to the health, education, and welfare of the minor child. This means that each parent gets to make the day-to-day decisions when the child is with him or her, but must cooperate and agree with the other parent on major decisions and certain actions, such as obtaining passports or traveling with the child. In most cases, the parties agree to or the court orders joint legal custody. Sole physical custody means that a child shall reside with and be under the supervision of one parent, subject to the power of the court to order visitation. This means the child lives the majority of the time with one parent and spends limited or restricted time with the other parent. This time with the non-custodial parent is called visitation. Visitation may be granted to one parent if physical custody is given to the other parent. Visitation may be open and liberal, such as mutually agreed upon by the parties, or more restricted as to specific dates and times, or in some circumstances may be monitored or supervised. Joint physical custody means that each of the parents shall have significant periods of physical custody. Custody shall be shared by the parents in such a way so as to assure the child of frequent and continuing contact with both parents. This does not mean an exactly 50-50 custodial timeshare, but rather that the child sees each parent frequently. In making an order or agreement for joint physical custody, one parent may be designated as the primary caretaker, so that this parent's residence is deemed to be the residence of the minor child. Custody orders may be agreed upon by the parties on their own or with court assistance. It is preferable for parents to make their own agreement regarding their children, rather than spend time, energy, and money in a disputed custody battle with the other parent. In any family law case, the parents may make their own agreement regarding the custody of their children, except they may not agree to terminate the parental rights of a parent. As a general rule, parental rights are only terminated in adoptions. Parents may use the services of the family law facilitator to assist with writing up their agreement for custody. The parties may also utilize the services of the Family Court Services mediator by filing an order to show cause for custody and attending custody mediation. The mediator will assist the parents in developing a parenting plan, which is in the best interests of the minor children. The parties may also hire a non-court mediator to assist them with making decisions on custody or other issues in their case. If the parties cannot agree, the court must make orders in the best interests of the minor children. The court must follow Family Code Section 3011 in making a custodial order and must consider the following: the health, safety, and welfare of the child, any history of abuse by one parent against a child, the other parent, or other history of domestic violence, the nature and amount of contact the child has had with both parents, and the habitual or continued use of illegal or controlled substances or alcohol by a parent. The child's wishes may also be considered pursuant to Family Code Section 3042 if the child is of sufficient age and maturity to have a preference as to custody. Generally, the judge will not speak to the child. The child's wishes will usually be made known through the mediation process or a custody evaluation. The weight to be placed on the child's preference depends on the age and maturity level of the child and on the underlying reason for the preference. Children should not be encouraged to participate in the court process by writing letters or statements to the court. Children, regardless of their age, should be shielded from the custody disputes between their parents. There are various types of court proceedings to obtain custody orders. Procedures vary by county to county, so you should read the local court rules, speak to the family law facilitator, or a private attorney as to the rules and procedures for your county. In some circumstances, the court will make emergency orders to protect the minor children. These orders are called ex parte orders and are made for a short period of time only if there is an immediate threat of harm to the minor children. Ex parte orders are generally disfavored and only should be requested if the children cannot be protected in any other way. Many family law cases take a long time to reach conclusion, such as a divorce. In these circumstances, the court may make temporary orders while the court case is pending. You may request temporary orders by filing an order to show cause, attending mediation, and a brief court hearing. Most of these requests are decided on the documents filed with the court and the mediation outcome, and do not require a long court hearing. If the parties do not have a final agreement for custody even after temporary orders have been issued, the court will set a trial or evidentiary hearing. At this time, witnesses and evidence will be presented, and the court will make a final decision on custody, which is in the best interests of the child. This proceeding is very complicated, and you should seek assistance of an attorney if possible. Most custody disputes are resolved without a trial. In a divorce, legal separation, or parentage case, it is possible that the respondent will not respond to the petition. In this type of situation, the petitioner proceeds by default to get a final judgment, including orders for custody, without going to court or mediation. The family law facilitator can assist with this process. Custody orders may be changed or modified by agreement of the parties or court order. If you do not have an agreement with the other parent, you may need to show a change of circumstance to modify a final custody order which has been made by the court. If you are simply changing the custodial schedule, you may not need to show a change of circumstance. To show a change of circumstance, you must explain what is different now from when the order was made, so that the order is no longer in the best interest of the minor child. The procedure for filing a motion to modify a court order is the same procedure for obtaining an original court order. You will need to file an order to show cause and attend mediation before going to the court hearing. Most of the modification requests are decided at the brief OSC hearing. However, the court may set an evidentiary hearing if more information is needed for the court to make a decision. The Family Code contains sections which apply special rules to situations in which the child may be in danger due to domestic violence, abuse, or the drug and alcohol use by a parent. Family Code Section 3044 establishes a presumption that a party who has committed domestic violence should not have sole or joint custody of a child. This rule requires the court to grant custody to the other parent unless the presumption can be overcome. The section sets forth factors the court must consider in deciding whether or not to grant custody to the perpetrator of domestic violence. Family Code Section 3041.5 allows the court to order a party to submit to drug or alcohol testing if the court finds there is evidence of drug or alcohol abuse by a parent. At this time, testing is limited to urine tests, and a positive test shall not be the sole basis for awarding custody to the other parent. If allegations of child sexual abuse are raised in a custody proceeding, Family Code Section 3027 allows the court to request that the local Child Welfare Services Agency investigate the allegations and report its findings to the court. The court may protect the children or make orders to determine if the children are at risk of harm from domestic violence or drug or alcohol abuse. If the court finds that a parent has committed domestic violence, as defined in Family Code Section 3044, the court may grant sole legal and sole physical custody to the other parent. A parent can be ordered to submit to drug or alcohol testing subject to certain limitations set forth in Family Code Section 3041.5. The court may order supervised visitation by a professional supervisor or a non-professional supervisor, depending on the particular situation. In particularly difficult situations, the order may be for therapeutic visits. Supervised visits often create problems with arranging schedules and payments for the supervisor. Therefore, they should be requested and ordered only if necessary to protect the children or to assist with reunifying the child and a parent. The court may order the parties and children to undergo a custody or psychological evaluation to determine the appropriate custodial order. These evaluations are often quite expensive and time-consuming, and are usually ordered only in extremely difficult situations. This video has provided you with a general overview of the rules and procedures which apply to child custody issues in divorce, legal separation, parentage, or domestic violence cases in the family courts in California. Guardianship and dependency cases are governed by a different set of rules, and you should seek legal advice if your case is a guardianship or juvenile dependency case. For more information on this or other family law topics, you may speak with the family law facilitator at the Superior Court or view other workshops on the web. If you would like specific legal advice, you should consult with a private attorney. This workshop was designed to provide basic information to help you help yourself if you are not represented by an attorney. It is not intended to replace in-depth legal advice specific to your situation, which can only be obtained from an attorney.